Good morning, everyone. Morning.
Good morning.
Countryside Rights Away panel, Friday the 8th of August at 10 o'clock, Oak Room, County Building, Stafford. Just like to say, the meeting will be webcast live, archived for 12 months, and it can be viewed on the following link. Staffordshire Public IT Core Portal Home. Over to you, Danjo. Oh, please, can you make sure your phones and things are off? Thank you.
Thank you, Chair. I'd like to read out the apologies received, and we've just had the one from Councillor Nick Thompson. Thank you.
Thank you, Joe. Can I ask item 2 on the agenda, any declarations of interest in the room at all? Okay, to take that as a no then, thank you. Could I just check the minutes for the minutes for the meeting held on the 18th of July, 25. If I could have a...
I'd like to propose that, Chair.
Okay, can I have a seconder, please? Okay,
Second.
thank you. That's approved then, thank you.
Silence, a true record.
Okay, thank you. Item 4, Heather Morgan. Thank you.
Thank you, Chair. Morning, Chair, members. This item was deferred from the previous panel meeting on the 18th of July 2025 and it's a request...
Sorry, Heather, I think it's item 4 is the Section 53 Delegated Decisions, just to confirm there wasn't any apologies. If you could read that out, that'd be good. Thank you.
Oh, so the delegated decisions, apologies. No, there are no delegated decisions, Chair.
Okay, thank you. Do I need a approval on that one?
No, that's fine.
Okay, item 5, that's the panel delegation report, please, Heather. Thank you.
Thank you, Chair. So this item was deferred from the previous panel meeting on the 18th of July and is a request for an addition to the scheme of delegation to authorise the making of a definitive map modification order when directed to do so by the Secretary of State for Environment, Food and Rural Affairs, following an appeal by the applicant against a decision of the county not to make the order. By way of background, the county has the power to determine applications which have been made under Section 53 of the Wildlife and Countryside Act 1981 following an investigation. Where the county refuses to make a definitive map modification order, the applicant has a right to appeal against that decision pursuant to Schedule 14 of the Wildlife and Countryside Act 1981. The appeal will be heard by an inspector of the Planning Inspectorate on behalf of the Secretary of State, and the inspector has the power to either dismiss the appeal, which means that the county's decision would stand, or to allow the appeal, which in those circumstances the Secretary of State will then direct the county to make the modification order. When a direction is received, the county must then authorise the order to be made. This is a routine decision as the county has no power to refuse to do so. Consequently, the panel is being asked to support the proposed measures as set out in paragraph 7 of this report, i.e. to support an addition to the scheme of delegation for the Director for Finance and Resources, to make a definitive map modification order where the County Council has been directed by the Secretary of State to make such an order following an appeal by the Secretary of State, following an appeal by the applicant against the County Council's decision to refuse to make the order. With the panel's support, the proposed addition to the scheme of delegation will then be referred to the Audit and Standards Committee and full council with the recommendation that it be approved and that the constitution and scheme of delegation be updated accordingly. Thank you, Chair.
Okay, thank you, Heather. Item 6.
We need to take a vote on
Oh, take a vote on that one then.
Any comments?
Yeah, we have any comments on that, please? No? Okay. Can I have a proposer then, please?
So Am I right in saying that this is the item that you asked for before about delegating responsibilities?
That's correct.
Okay, well, I've had a think of it, and based on what you've said, it would mean that the officer wouldn't come to us. He would then have delegated powers to decide on it without coming to the panel.
Yes, that's correct. It would be an authorised officer. It wouldn't just be one of the officers that bring the report. So it would be the Director of Finance and Resources would delegate that to a specific officer.
Okay, thanks for that. So my understanding is that we're here with the panel, and then would it, so if we didn't have this officer come back to us, it would then still go through scrutiny?
No, the scrutiny is only for this report to go through. So it's just for the delegated powers to be put into place. Once the delegated powers are put into place, then those decisions would just be made by the authorised officer under the scheme of delegation.
Okay, so I'm a little bit concerned as that we wouldn't have oversight of the decision. I think it's important that we do see all decisions here at the panel. Thank you. Anyone else?
Yeah, it seems obvious that I think we do need a panel to make the decisions. In the past, I mean, I think we've got, is it 250 cases outstanding going back 20 years? I think we need to get on top of this, and I think to give delegated powers, I don't think we should do it.
Chair, could I just clarify, this isn't the actual decisions of the applications. They will still be coming to the panel. This is just where we've been directed by the Secretary of State to make an order. We have no power to refuse to do that, so it is just a routine decision. So the panel will already have made a decision, the panel will have refused that, and then the applicant will have appealed to the Secretary of State. Secretary of State takes a different view and directs the County Council to make that order. It's just that decision of that at that point of making that order, which we have no power to refuse to do in any event. So it is just a routine decision. It isn't one of the ones off the list that you've just referred to, if that makes sense.
Any other comments, please? Warwick?
What was their interest in making that application in the first place?
Quite often the applications will come from users, people who like to use the routes on bridleways, and they probably have used the route on bridleways for a number of years. That's what they will be alleging. Say they want that to be upgraded to a bridleway because in their view, in law, it should be a bridleway and should be recorded as one. That's usually where the applications come from, or often or it could be historical evidence where it's because in their view, the application is alleging that the definitive map that we hold is incorrect in that it's showing it as, for example, as a footpath rather than a bridleway, but historical evidence or evidence of use will prove that it should be recorded as a bridleway. So this is about making sure that the definitive map is up to date and accurate. So it's not as a proposal to do it, it's more of an allegation that our map is incorrect and we should be recording it correctly.
Well, it's not incorrect, is it? Because
it's the definitive map is the legal evidence of what exists as it stands, but that is subject to any evidence that may come forward that suggests that higher rights or other rights exist, or that the rights perhaps don't exist. So anything on the definitive map is always subject to any other evidence that we were previously unaware of. It could be historical evidence going back to sort of even the 1600s of something that happened at that time that suggests that it's something else rather than what we've actually recorded, because the definitive map was generally put together by parish surveys. So that will have just been people who in the, the parish councils and people who worked or lived in that area. They will have put information in at the time. So the definitive map will have been put together from that information, but that isn't necessarily all the information that's out there. It's just that we perhaps weren't aware of something that actually recorded it as something else previously.
Well, can the Secretary of State just make a decision based on how they feel in the morning, or I mean, or do they have to justify it? And what was their justification? What did they have that we didn't have?
It's about the interpretation of the evidence. So we will have come to the panel with the evidence, and we'll have interpreted it a particular way. It isn't an exact science. So it also depends on the legal test that you need to prove. So it's some of them are reasonable allegations, some of them are a balance of probabilities, but different views can be taken. So it might be something that's sort of balanced, and we take one view, the Secretary of State will take a different view. It's just the general sort of legislative, the general legal process that often with all sorts of decisions, legal decisions, an applicant or some other person will have a right of appeal against that. So it's just the same process, the same sort of principle really, in that if a decision is made one way, whoever wanted that decision to be made another way has a right of appeal against it. So, and that's all set out in the legislation, so we have to abide by that.
Can I ask, why are we asking for this now at this point in time, please?
Yeah, in recent years we've had more people come into the team, so we're actually dealing with a lot more of these. In the past, we haven't had so many of these decisions go that way, so it's not been an issue, but we are having more of these coming through now, so it's more of a problem for us because it's taking quite a lot of time to write the reports and then bring the report to panel, rather than just getting a decision made through a delegated process, which would just be essentially just sending an email.
Have we had a public right-of-way panel in the past from previous councillors?
Yes, there's always been, to my knowledge, there's always been a panel that deals with these. But like I say, there was a long time where there weren't very many people dealing with these, so there weren't many decisions being made. Most of them were probably going our way anyway, so it wasn't really too much of an issue. So the occasional one will have come through where we've been directed to make an order, but because we're making a lot more decisions, we're being directed to make a lot more orders. So it's really, that's why it's become an issue now.
Can we delay this process and ask for some legal advice?
Yes, of course.
Mr. Chair, I think given what you said, the lack of manpower, you said, and then maybe people not coming to the panel, but we've got quite a good turnout today. I think with the new administration, we'll be able to make some good decisions. But if we don't have those cases brought before us, we won't be able to decide upon them.
No, I'm sorry, let me clarify what I said. It was, I wasn't meaning panel members, lack of panel members, I was meaning lack of staff. The team who deal with these has recently increased, which means that we are bringing more to the panel and we are getting more decisions, so there's more decisions going against us as well because of the volumes increased. It's not to do with the fact that there's more, or, you know, how many panel members there are here or how many meetings we have. Apologies if for that misunderstanding.
Thanks very much for clarifying that. So you've got more staff on board. I think going forward, if we could be part of the process, we'd much prefer that. Well, I personally would, to be part of the process. We are in a new administration. We're the new kids on the block, as Nigel's called us. And we're just keen to not have access to that would it would certainly not. I just think it's the step in the wrong direction, personally. We want to be part of it. We're keen to support you and help you. So bring us the cases and we'll look at them.
Yeah, I agree with that. If we need to do more meetings at of the panel to get through these cases, I think we're all prepared to do so. So hopefully now, if we can carry on as we are, we can get through this backlog. Now you've got more officers and we've got a more keener panel. So, yeah, okay.
Can I just clarify? So I'm a bit confused. Is you guys asking for power to make decisions that normally need a vote because there's so many such a backlog of cases? Is that what we're asking for?
No. Those decisions will already have been. These decisions will already have been into panel.
So this is just the Secretary of State ones?
The ones that I've brought the report about are simply the ones where we've been directed by the Secretary of State, not any of the other decisions. Okay. Yeah.
Okay, thank you. So can we ask for a delay for the minute? Probably till the next meeting.
You're entitled to defer matters, of course.
It's the Secretary of State, can't argue it, can we?
We can ask.
Because, I mean, if we're going to wait through all these cases, I mean, well, the ones we're going to definitely, lose, like this one, we shouldn't waste the time on it.
I think if we do delay it till the next panel meeting, we'll get more information on it if that's okay, and we'll decide then.
Of course, thank you, Chair.
Thank you. Moving on.
So you need to take a vote on
Oh, we do need to take a vote on this, don't we?
So all those in favour?
All those in favour, please,
Of deferring.
of deferring the decision.
Can we have a show of hands?
Show of hands.
Okay.
Oh, aye.
So 1, 2, 3. And then all those against? 1 abstains. Yes, certainly. Just put your mic on.
Thank you. Just feel a bit uncomfortable. I'm not questioning the officer. They do a very good job, and I think we as a panel are very keen to go forward because I'm new as well. I'm just wondering if it's possible if we could have an extra meeting when they have these orders coming in from the Secretary of State. I'd be very happy to come to an extra meeting. I certainly am not calling our officer into question at all. You do a very good job, but I'd quite like to have that opportunity of an extra meeting. So I'm not questioning you, Chair, your decision at all. It's just, I think that we just have an extra meeting. Thank you.
Yeah, I'm all for more communication, absolutely. Thank you very much.
Yeah, I've always said in the past, I think the officers do a fantastic job.
Yeah.
Some of the paperwork they have to go through and all the procedures, absolutely amazing. So I'd just like that point noted, please.
If I can come back in on that, Chair, forgive me for this, but I'm just thinking that we don't necessarily have to drive to the county buildings. We could have a Teams meeting with the officer to discuss that. That would, eliminate problems.
Yeah,
Okay,
we could
thank you.
organise that, yeah.
Thank you.
That's brilliant. Okay, moving on then. Item 6 on the agenda. Schedule 14 appeal for the direction of the Secretary of State for Environment, Food and Rural Affairs to make a definitive map modification order. Application to upgrade public footpath 8 at Waterhouses to a public bridleway. If I could ask Stephanie, please.
Good morning, Chair and members. This agenda item is seeking authority from the panel to make a definitive map modification order as a result of the County Council being directed by the Secretary of State for Environment, Food and Rural Affairs to make an order in relation to a Section 53 application. The application in question was to upgrade existing public footpath 8 Waterhouses to a public bridleway. The application was made on the 2nd of June 2019. After a detailed review of the evidence, officers concluded in their original report that the legal test of balance of probabilities had not been met to justify the upgrading of public footpath 8 to a public bridleway. The application was considered by the Countryside and Rights of Way panel at their meeting on the 13th of September 2024. The members at that meeting accepted officers' recommendation and determined that no order should be made to upgrade the route in question. Following the decision, officers contacted the relevant parties, including the applicant, on the 16th of September 2024 to inform them of the outcome and to advise them of their right to appeal under Schedule 14 of the Wildlife and Countryside Act 1981. The applicant did exercise their right and submitted an appeal to the Secretary of State within the statutory 28-day timeframe. Upon review, the Planning Inspector, on behalf of the Secretary of State, found in favour of the applicant and has allowed the appeal. As a result, the Secretary of State has now directed the County Council to make a definitive map modification order to upgrade public footpath 8 to a public bridleway. This order must be made within 3 months of the Planning Inspector's decision, which was made on the 9th of July 2025 and can be seen at Appendix C. Therefore, officers formally seek the authority from the panel to proceed with the making of this definitive map modification order as directed by the Planning Inspector to upgrade public footpath 8 Waterhouses to a public bridleway under the County Council's seal. Thank you, Chair. I'm happy to take any questions.
Any questions from anybody? No? Okay. Can we take a vote, please? Thank you. All those in favour?
1, 2, 3, 4, 5.
4 in favour.
All those against? 1 abstain.
Abstained, yeah.
Thank you very much.
Okay, thank you.
Thank you, Chair. Thank you.
Moving on. Item 7 on the agenda. Section 53 application to upgrade the public footpath 140 Waterhouses part to a public bridleway to add a public bridleway between public footpath 140 Waterhouses and public footpath 66 Waterhouses to upgrade the public footpath 66 Waterhouses to a public bridleway and to add a public bridleway from the steps Cottage to the S53 at Waterhouses. That's a mouthful. Stephanie, please.
Thank you, Chair and members. Yes, that's me again, I'm afraid. This report is based on an application made under Section 53 of the Wildlife and Countryside Act 1981 for a route in the Staffordshire moorlands commencing off Duke's Lane in the hamlet of Brumishaw and running as far as the A523 near to the village of Waterhouses. The application was submitted on the 6th of July 2020 by the Staffordshire Moorlands Bridleway Group, and the route can be seen marked A to E at Appendix B of the report. The recommendation from your officers is to accept the application and to make an order for a public bridleway along the claimed route. The applicant's evidence included the Calden Tithe Map and Award of 1845, a copy of the Finance Act Plan 1910, a copy of the Parish Survey Card for Public Footpath 140 Waterhouses and its accompanying register, a copy of an Ordnance Survey 2-inch drawing dated 1836, and 2 photographs of the route. Their evidence also included a copy of the second edition revised to definitive map dated 1989, 4 user evidence forms, a copy of a document titled Law Report, User Evidence Less Than 2 Years, drafted by Brian Thompson, and a document with the title Former RUPS in Staffordshire, drafted by Brian Smith. Staffordshire County Council investigated and discovered further evidence in their efforts to ascertain the veracity of the route. This included plans for the Leek, Calden Low and Hartington Light Railway and its accompanying book of reference, a record evaluation book for the parish of Calden, and a copy of both Calden Parish Tithe Map and Waterfall Parish Tithe Map. Also discovered were copies of Ordnance Survey maps published 1863 and 1881, Parish Survey cards for Public Footpath 66 and Public Footpath 89 Waterhouses, and a copy of the Town and Country Planning Act 1990 Stopping Up of Highways, West Midlands No. 6, Order 2024. Following receipt of the application, an initial consultation was undertaken of the applicant, landowners, statutory bodies and user groups in September and October 2020. The Open Spaces Society contacted the council to advise that they supported the application, although they did not provide any evidence. The report was drafted and sent out for consultation on the 12th of May 2025. There was no response from any party. The most significant piece of evidence provided included the railway plan and book of reference. There are two plans available. Railway Plan 1 shows the whole of the claimed route. The entirety of the sections between points A to B and points D to E are shown to be detached from surrounding fields, which are indicative of higher rights than a footpath. Parts of the sections between B and C and D are also shown as detached from adjoining fields, with the remaining length of route indicated as a double-pecked line. The whole of the claimed route shows markings suggestive of higher rights than those of a footpath. Railway Plan 2 shows sections A to B and partway to C. Its accompanying field book states the road to be held by Parish Council, indicating at least the start of the route to be public. The Finance Act plan and book of valuation of 1910 is also significant evidence, albeit it only shows the start of the route. The plan depicts the route with continuous solid lines being detached from the adjacent fields. This suggests it has public and also higher rights than those of a public footpath. The tithe maps of both Waterfall and Caldon support the evidence for the route. Whilst not as evidentially influential as the Railway Plan and Finance Act documents, the Waterfall tithe map specifically shows a detached route from the A523 as far as the River Hamps. This section of route is also named as a bridle road in the accompanying index. The Caldon tithe map records the commencement of the route described as a road, and again shows it to be detached from adjoining fields. The parish survey cards provide additional evidence. Public footpath 140 Waterhouses shows that the County Council believed that the route between points A to B and partway to C was once a road used as a public path. Whilst this does not automatically indicate that the route should be upgraded to a bridleway, the Railway and Finance Acts and the tithe documentation are supportive of bridleway rights. Parish Survey Card 89 Waterhouses and Parish Survey Card 66 Waterhouses cover part of sections B and C and sections C and D respectively, although they do not indicate any higher rights than those of public footpaths. There was no survey card for the section D to E because this section of the route was listed as an unclassified road in 1954 and therefore fell outside the scope of the survey. The Ordnance Survey maps provide some evidence of higher rights, although they do not carry a great deal of evidential weight, as they only show the physical feature on the ground. They also do not show whether the rights are public or private. The applicant provided user evidence forms completed by 4 users. Whilst this was supporting evidence, the evidence did not pass the test laid down under Section 31 of the Highways Act 1980 as being sufficient to claim the route alone, and the user evidence also failed under the common law. The applicant sent photographs of the route, a document titled Former RUPS in Staffordshire, and a document titled Law Report, User Evidence Less than 20 Years. This has been commented on within the report but carries little evidential weight. Your officers also found a stopping up order which came into effect on the 17th of April 2024. The order covers the section of claimed route between points B to C. The developer, in whose favour the stopping up order was created, provided a new highway as an alternative to the section of public footpath 140 and public footpath 89, which was stopped up and diverted. It will be noted that there is different evidence for the different sections of this route. This, together with the current alternating statuses between that of a footpath and a bridleway along the claimed route, has resulted in the requirement for 2 legal tests to be met before a modification order can be made for the route. These tests include the balance of probabilities and reasonable allegation. For sections A to B and sections C to D, it is the opinion of your officers that based on the balance of probabilities and then in the light of the evidence, these sections of route, which are currently public footpaths, subsist as bridleways and should therefore be upgraded to public bridleways. For section B to C and section D to E, it is the opinion of your officers that the evidence suggests a route is reasonably alleged to subsist along these sections of route, which are currently not shown on the definitive map and statement and should therefore be added as sections of public bridleway. Officers therefore recommend that members accept the application based on the reasons contained within the report and that an order should be made to add and upgrade the sections between A to point E to the definitive map and statement. I'm happy to take any questions.
Okay, thank you for that, Stephanie.
Come up for air.
Any questions on that, Liz? No? Okay.
All those in
Shall we
favour?
have a proposal then? Oh,
Through you, Chair, sorry. I just want to make absolutely sure through the officer that we have no recorded objections. I think from what listening to you, I think no one is objecting to it.
No, Madam, nobody has actually responded to us, and so therefore, no, there has been no objections.
Very thorough report, well done.
so we haven't had any objections at all on the proposal? Okay.
No, we haven't.
Shall we take it to a vote then? All in favour, please?
1, 2, 3, 4, 5. In favour, any against? No, 1 abstention.
1 exemption, okay.
Thank you, Chair.
Any questions? No? Okay, thank you. Section number 8 on the agenda then, please. Section 53 application for the addition of a public footpath between public footpath 28 and Bridleway 55 in the parish of Denstone. Could I ask, is it David? Oh, Laura, please. Thank you.
Thank you, Chair, members. This is an application to add a public footpath along the line of the route on the plan attached to Appendix B. The application is supported by user evidence. Turning to the recommendation, that is that a modification order should be made to add a public footpath along the line of the route marked A to B to D on the plan attached to Appendix B. The applicant submitted 9 user evidence forms completed by members of the public who claim that the route has been used by them on foot and the route was still being used up to the date of application. Section 31 of the Highways Act 1980 provides that a public right-of-way can be established through at least 20 years of uninterrupted public use as of right, unless the landowner can demonstrate no intention to dedicate the route. This presumption, introduced by the Rights of Way Act 1932, places the burden on the landowner to rebut dedication. For a claim to succeed, it must be shown that the public used the route openly, without interruption, for the 20 years leading up to when the right was brought into question. If no clear challenge to public use exists, the date of a modification order application under Section 53 may be used as the date of challenge. In this case, the relevant period is from 2003 to 2023, calculated retrospectively from the application date of the 8th of February 2023. The applicant submitted 9 user evidence forms from members of the public who say that they've used the route during the relevant 20-year period. 8 of them have used it for the entire 20 years, while 1 person has used it for 17 of those years. The evidence shows that the route has been used continuously for around 40 years without any interruptions. None of the users asked for permission or used force to access the route, which supports the legal requirement under Section 31 of the Highways Act 1980, that public use must be as of right. People regularly use the path as a convenient link between 2 existing public routes. The law requires that the public use must continue for at least 20 years, and the submitted evidence meets this requirement. Case law says that the level of use must be enough to make a reasonable landowner aware that the public are using the path as if it were a public right-of-way. In this case, the route is clearly used regularly and all year round. An important physical feature of the route is a footbridge that provides safer pedestrian access. The evidence suggests this bridge was constructed after previous wooden sleepers were washed away. However, it is unclear who installed this footbridge. It was not the local authority, and the council is not responsible for maintaining it. Still, its presence indicates the route was in frequent use. Another part of the legal test is whether the landowner tried to stop public access, for example, by putting up signs blocking the path or stating that there's no right-of-way. In this case, there is no sign the landowner did any of these things, and therefore there's no evidence to disprove public use. The section of the route from B to D is used more often than that of B to C, which according to the evidence can become unusable in bad weather. This indicates that the route A to B to D is the preferred and most regularly used section of the route. Given the consistent and ongoing use and the absence of any attempt by the landowner to prevent it, it is considered reasonable to allege that the section of the route marked A to B to D meets the legal test for recognition as a public right-of-way. There are two separate tests that must be satisfied. The first test is that it will be necessary to show on the balance of probabilities that the right-of-way does exist. And for the second test to be satisfied, the question is whether a reasonable person could reasonably allege that the right-of-way exists, having considered all the relevant evidence available. In conclusion, the evidence shows that a public right-of-way marked A to B to D on the plan attached to Appendix B with the status of a public footpath, which is not shown on the definitive mapping statement, is reasonably alleged to subsist. It is opinion of officers that the County Council should make a modification order to add the public footpath marked A to B to D to the definitive mapping statement of public rights of way for the Borough of East Staffordshire as a public footpath. The width of the route should be 1 metre throughout its length. I can confirm that the local member, Councillor Hales, raised the following question via email. If the application is approved, would Staffordshire County Council assume any responsibility for the ongoing upkeep and maintenance of the proposed public right-of-way? Given that the evidence indicates the path is constructed from earth, could this potentially expose the council to future liability claims arising from accidents, particularly in cases of adverse weather conditions or deterioration of the surface? Officers have responded to Councillor Hales to confirm that the maintenance of the route has no bearing on whether the route exists in law and the legal tests that need to be applied. It's not a consideration for this tribunal of fact. If members were to agree with officers' recommendation and add the route, it would be for our colleagues in the Rights of Way team to identify any issues going forward if the route was obstructed, which would include surface damage, to liaise with the landowner to reach a resolution. Thank you. I'm happy to take any questions.
Okay, thank you, Laura. I think Councillor Broom, question about this.
Thanks, Chair. Did you say that some part of it was not upkept? Is it in poor condition? Did I get that right?
The public footpath at the moment, from the evidence that's been supplied, is an earth track. So it's not on the definitive mapping statement, so it's not the responsibility of the council to currently maintain the route.
And the area has been used legitimately. Is it the 20-year rule that decides that?
It is 20 years, yes, but the people that have submitted the application, the user evidence that's submitted with the application, would suggest that people have been using it for approximately 40 years, but for the duration of the relevant 20-year period as well.
Okay, thanks very much for that clarification.
Yeah, I know the path in question. I've cycled past it many a time, and I think I went down it once, so maybe I should have declared that.
Yeah,
Neil?
Neil.
Is that the only access across the land, or is there another access across the land?
As far as I'm aware, it's the only access across the land. It links one public footpath to the public bridleway, 55.
Okay, thank you.
Any other questions? No. Okay. Can we take a vote on that then, please? All in favour, please?
1, 2, 3, 4, 5, 6, 1 abstention.
Okay. Against? No. Okay, thank you. Are there any questions at all at the minute so far? No. Moving on then, item number 9 on the agenda. Are we on, no, this one's 9, I think. Yeah, 9. Section 15 TVG application to register land bounded by Newcastle Road, Coalpit Hill and Thomas Street, Talke, Newcastle-under-Lyme, as town or village green. I think this one's for David. He's been a bit quiet today.
Yes. Thank you, Mr. Chairman, members of the panel. Last but not least, we have an application to register land as a town or village green under Section 15.2 of the Commons Act 2006. And the land in question is bounded, as you rightly say, by Newcastle Road, Coalpit Hill and Thomas Street in the parish of Talke in the district of Newcastle-under-Lyme. Your officers should say at once that the inspector's recommendation is to accept the application and to add the land to the register of commons and village greens with the modifications highlighted in the report. The application land extends to approximately 1.71 hectares or 4.22 acres and forms a triangular shape within the neighbourhood of Talke. However, Mr. Chairman, this is not a simple triangle, as there is land at the western end of Thomas Street at its junction with Coalpit Hill, which appears to have been regularly used as a car park. This section of the application land appears to have been highly contentious for many years, as indicated by both the applicant and the landowner, and the inspector recommends that this be severed from any registrable land. This constitutes the main part of the modifications which the inspector has identified and which your officers will clarify at the end of this summation. The application is referenced NVG 26, and in line with the inspector's report dated the 24th of April 2025, it is further recommended that all interested parties should, in due course, be notified of any decision. The application itself can be seen in Appendix A, and the landowner was and is Newcastle-under-Lyme Borough Council. After a period of inactivity on the file, the landowner was contacted to establish whether or not they wished to update or refresh their objection, although in response they informed the County Council they wanted to withdraw all prior objections and would not be making further ones. The Council, acting in its capacity as Commons Registration Authority, instructed Mr William Webster, barrister at law, as an independent inspector to advise on the matter and based on the documentation alone. Turning to the legal framework, Section 15.2 of the 2006 Act enables any person to apply to register land as a town or village green, provided a significant number of the inhabitants of any locality or of any neighbourhood within a locality have indulged, as of right, in lawful sports and pastimes on the land in question for a period of at least 20 years, and b, they continue to do so at the time of the application. In his investigation of the matter, Mr Webster has detailed the legal requirements for registration and has analysed the evidence contained within Appendix C very thoroughly. He has detailed these points in his report at Appendix B. It is not your officer's intention to read through the report here, but it may be summarised as follows. In respect to the requirement of lawful sports and pastimes, we find that these activities are sufficiently described by the witnesses in a well-supported and well-documented application. The types of lawful sports and pastimes which witnesses have engaged in are noted in the evidence and include a range of popular activities such as dog walking and physical exercise. As such, the inspector holds that the lawful sports and pastimes requirement is duly satisfied. In respect of the requirement that the land should be used by a neighbourhood or locality, the inspector highlights that the application should be treated as a neighbourhood case, extending to the neighbourhood of Talke and within the locality of Newcastle-under-Lyme. As such, the inspector holds that the neighbourhood or locality requirement is duly satisfied. In respect of the requirement for a significant number of user, the applicant has produced evidence from numerous local people who live in the streets close to the application land, and it appears that a significant number of them have indeed used the land consistently. As such, the inspector holds that the significant number of user requirement is duly satisfied. In respect to the requirement for use as of right, the inspector concludes that the use of the land could not have been by right, as we have no evidence to support this. The land was not managed in such a way that inference could have been made of either a positive or overt act that was intended to be a permission to use. And as a result, therefore, use of the land could not have been by right. The landowner's initial defence, which could be described as the Barker's defence, also falls away, as it cannot be shown that the land was ever held for any statutory purpose, or more particularly, a statutory purpose linked to public recreation. The inspector further holds that the application land has been merely maintained or managed by Newcastle-under-Lyme Borough Council without due regard to its purpose, and as such, a by right defence is therefore inadmissible. As such, the inspector holds that the as of right requirement is duly satisfied. In respect to the requirement for 20 years usage, members will note that of the 39 witnesses who signed statements in the evidence, 34 attested to have used the land for over 20 years, while the remaining witnesses also demonstrated a protracted period of use. As such, the inspector holds that the 20-year requirement is duly satisfied. Turning to the modifications, members will see in the appendices a plan of the land in question. To elucidate this somewhat, it has been recommended by the inspector that several areas be excluded from registration, namely the footpath crossing the application land between Newcastle Road and Coalpit Hill, as footpath use alone would not satisfy the requirements for a village green. In addition, the land to the south of Thomas Street is also non-registerable due to its consistent use as a car park, while the two small areas of highway land edged in green on the plan should also be duly severed. Highway land is not registerable as a village green. Lastly, the steep embankment running around the perimeter of the site and adjoining Thomas Street should also be excluded, as it would be problematic to demonstrate that lawful sports and pastimes had occurred there. In conclusion, therefore, it is recommended that the application succeeds under Section 15.2 of the Commons Act 2006 and should be added to the Register of Common Land and Village Greens with the modifications outlined above. Thank you, Mr. Chairman. I'm happy to take any questions.
Thank you, David. Any questions, please? Warwick? Yeah, Grand Neil.
Well, yeah, I think it's a good application.
Is the land still used as a car park, the one that's to be severed?
Thank you, Mr. Chairman. It is indeed, yes.
Do you want to ask a question?
No question, just comment. I think it's a great application. It's been outstanding since 2011. I think it's great. It's come forward and we're going to accept it, I hope.
Okay, thank you. Can we take a vote on this then, please? All in favour?
Yep. That's unanimous.
Yeah.
1, 2, 3, 4, 5, 6, 7.
Okay, that's approved then, thank you. No private items, item 10. So this concludes today's meeting.
Thank you very much.
Thank you very much for everybody in attendance. Thank you.